Welcome back. You're watching Big Deal, and we are discussing the new changes that could come in the Competition Commission Act and how it's going to really be a big game changer for the deal making in the country. Now, Shweta, we were discussing the deal threshold. But on the other hand, the control aspect, which is defined in different ways by the different regulators, has a very, very meaningful role to play when it comes to the clearances and approvals by various regulators. In CCI's new definition or an updated definition under the amendments, material influence has been added to the control aspect. How do you read into it, and what are the aspects now to be watched out for?
Okay, so I think this is, I think, perhaps one of the most significant changes as far as codification is concerned. Whilst the CCI's practice has been to look at control in the broadest sense, so they look at it as a sliding scale all the way from de jure control, where you have more than 50% of the board or more than 50% of the shareholding, to de facto control, where you perhaps have less than 50% of shareholding, but there are other circumstances, for example, agreements or financings, or the presence of important shareholders, which can give the de facto control. And then at the far end of that is what is called material influence. Now, what is material influence is very very nebulous, but it is certainly lesser than the erstwhile understood threshold of decisive influence. So when the merger control regime started, decisive influence was seen as the litmus test. So where there were veto rights, which could cause a deadlock in relation to sort of strategic matters such as KMPs, business plans, entry or exit of line of businesses. But over time, that has got muddied. And now this is muddying that a bit further, because it gives the CCI to look at the nature of control as opposed to some objective metrics. Now, in terms of what would be seen as control, there could be multiple aspects. And in some of the cases, the CCI has expressed its view to look at things like the shareholding. So this could also mean like the cap table or shareholder arrangements. It could mean special rights. And these don't necessarily have to be only veto rights in relation to the 3 or 4 decisive influence matters, but could be much broader than that. For example, to include change of auditor or change in the MOA, AOA of the company, which gives the investor the ability to influence the way it is done.
Yes.
And also to include the status and expertise of an enterprise or a person, where the enterprise holds, where such a person has a great, personality or influence, or is an expert, that may be also seen as giving control. Also, there's board representation and structural or financial arrangements, which the CCI has built out.
So Shweta, yes, so a lot has been left to subjectivity, and the fine print will need to be defined much better in this, because then otherwise every deal can come under the purview of this material influence by an investor. Say, for example, Gaurav, throw more light on this particular aspect. A lot of times private equity with a minority stake wants a board nomination for investor protection. Can that also come under the purview of material influence by a minority shareholder?
Yeah, so if we were to go by the practice of the last 2 years, it seems like that the CCI is targeting at review of private equity deals where there is an ability to appoint a director. Now, the logic that the CCI is looking at is effectively, earlier they used to look at the ability to take strategic decisions of the target, but now they're simply looking at the ability to participate in the management and affairs of the target, right? So if you simply have the ability to participate on the board and make your thoughts presented to the board, that the CCI is viewing as having some sort of an influence that you have, that you can command on the board by sharing your thought process.
Right.
So the way this is heading, it seems like, what is typically considered to be an investor protection right, because you would want to see how the company is doing, whether the thousands of crores that you have invested are protected by the right
So
commercial
here I would
policies.
like, Gaurav, this will need a much deeper discussion, because the board composition in itself, the law presents that no one person has more rights, and the board itself is composed in such a way that there is enough democratic decision making on the top. But very recently we have seen Yes Bank investors having a board nomination on Yes Bank, RBL Bank investors wanted for their investor protection. So this is an important point. But one final word, Gaurav, and very quickly, open market purchases, and that with CCI approval being subject to it, can be done immediately. What are the guardrails that needs to be defined here? How will it work? Very quickly.
So as of today, you cannot make open market purchases before you notify the deal to the CCI, because that amounts to gun jumping. What this proposed amendment really helps is that you can make a post facto notification to the CCI. The things to be careful about is to in terms of guidelines, we need to ensure that proper escrow mechanisms have been put in place, and how those escrow mechanisms would work to ensure that the acquirer indeed does not exercise any beneficial rights over the shares that are put into the escrow.
Yes.
So those kind of guardrails are required to be put in place, because
all right, Gaurav. So two
law,
important takeaways from you, that and CCI has also explained it, that probably the ownership of that particular shares will be in escrow till CCI approval comes, but the transaction can be done at that very moment, so that there is market volatility that can be avoided over a longer period of time. This will require a lot more work also, because if there is a material difference in the way the deal is structured after CCI approval. So thanks, Shweta, as well as Gaurav, for putting a lot of insight into some of those game-changing amendments that are really proposed. Of course, we have to see what really comes out in the fine print. But I would always say that precedents coming in from CCI's approval process on various deals will set the ball rolling on how CCI's working really depends, and how it approves various deals. So we'll be watching out for that and the approval of these amendments. With that, it's a wrap on this edition of Big Deal. Thanks so much for tuning in.